Today we are going to be talking about Frazier v. the ATF. More specifically, the overturning of the prohibition that 18 to 21-year-olds cannot have handguns. Now, before we begin, USCCA, which sponsors this video, is doing a giveaway. It's an event that ends very soon, so you're going to want to go into the description below this video and definitely take part. What they're giving away is very cool. I can give you a hint. It'll fit in your holster. All right, with that said, let's talk about Frazier v. ATF. So this was a challenge that was brought in Virginia specifically as it relates to the federal prohibition of 18 to 21-year-olds not being able to acquire a handgun. More specifically, 18 to 21-year-olds not being able to go through a gun dealer to get a handgun. Interestingly enough, there are some exemptions for 18 to 21-year-olds to be able to acquire a handgun. This usually deals with what we call an interfamilial transfer, notwithstanding military exemptions and things like that. So these particular plaintiffs and those similarly situated brought a lawsuit against the ATF saying that their Second Amendment rights were being violated. So Judge Robert Payne issued his decision. Now, every so often, decisions come out that are just an absolute pleasure to read. Those of you who've read anything that was drafted by Roger Benitez down in San Diego, some of you may know of him as Saint Benitez, some absolutely exquisite and logically consistent Second Amendment jurisprudence. I would put Judge Payne in that same category. Now, I will also give you a couple of caveats because in this decision, he does actually articulate a couple of things that troubles me a little bit, and we'll discuss that as well. Specifically, the state argues that 18 to 21-year-olds essentially have no Second Amendment rights. More importantly, the Second Amendment should not apply to this subset of individuals because at the time of the ratification, again, using that Bruin test, at the time of the ratification, 18 to 21-year-olds were not considered the people. Now, this is interesting because both the state as well as the Everytown for Gun Safety, the anti-gun group, they both argue that the court should use an originalist interpretation of the Second Amendment as it relates to this one specific facet. Every so often, the sides kind of change positions to try to get whatever desired outcome they're looking for. Here they're saying, well, at the time of the ratification, the age of majority was 21. Before that, they were not actually construed as part of the people. And the judge says a brilliant concept, and he says we cannot use what the people were construed as at the time of the ratification. You would come up with some fairly noxious outcomes if we were to do that. Women couldn't own guns. African Americans couldn't own guns. Native Americans couldn't own guns. If we were going to simply restrict ourselves to what the people were known as back then. He then goes through and says, well, and there were caveats. I mean, there were militia members that were younger than 21. So this concept of 21 being the age of majority, that's it's somewhat fluid. More importantly, if you're going to go ahead and create these types of restrictions, then the Second Amendment would be the only constitutional right that comes with essentially an age carve-out. And that doesn't make any logical sense either. So technically speaking, an 18-year-old, if you were to take this to the same logical conclusion, an 18-year-old, though they could vote, they could not exercise their Fourth Amendment rights against, unreasonable searches or seizures, or their Fifth Amendment rights against self-incrimination. So the judge pretty much swats that down in its entirety. Now, he ultimately will come to the conclusion that the Second Amendment absolutely protects an 18 to 21-year-old's right to be able to acquire a handgun. He comes to the correct conclusion, in my opinion. He also says a couple of things, like I said, that are a little troubling, right? So one of the things that he articulates is that you have an absolute right to be able to acquire a firearm. That the Second Amendment sort of creates this protection that, and he says something also really, really germane. He says the word in the Second Amendment is infringed, okay? The right of the people to keep and bear arms shall not be infringed. It's the only time in the Constitution where that word is used, okay? Now, infringement also protects against what he refers to as encroachment. Those laws that seek to nibble away at the opportunity for people to be able to exercise these rights are also, by definition, unconstitutional. Okay, cool. We're on a good place here, all right? But then he says, while there is a constitutional right to be able to acquire a firearm, there is no constitutional right to be able to sell a firearm. This is where things get a little bit more problematic, because now he's focusing in on individuals that have essentially been empowered by the government to be able to sell guns, specifically FFLs. Like I said, this is really somewhat, difficult to accept. Property, by definition, has to have a capacity to be alienable, essentially meaning if you own something, one of the tests to determine whether or not you actually own it is whether or not you have the right to sell it and to get rid of it. If you don't have that right, you truly do not have ownership. What you really have is licensure by someone else to be in possession of that particular item. And this could be taken to its logical conclusion to suggest that while the right of the people to keep and bear arms exists, nowhere in the Constitution does it say that the right of the people to own arms. And I can see that argument starting to manifest in subsequent cases. So that's something to be on the lookout for. That might be something that becomes a little problematic. Irrespective, at the end of this decision, we do come to what I would call, again, the correct conclusion. This is obviously there is an attempt by the government now to appeal this. If they are unsuccessful on their appeal, then 18 to 21-year-olds will be able to acquire handguns, which, again, I would believe is consistent with what the framers had as they drafted the Second Amendment. In any event, if you need to contact me, please feel free to do so. You can email me at steven@artemishq.com. As always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.
Before you go, you just missed one of our best videos that got over 500,000 views. Click right here to watch it now.